Hi everyone, Harry here to talk about Special Counsel Jack Smith's assertion to a court that there is evidence of a crime of obstruction by Donald Trump. And the context here is to activate the so-called crime fraud exception to the attorney-client privilege. Sounds very legal, but it's pretty straightforward. So just take a medium breath. It's not that big a deal. Okay, you'll remember this is the whole Mar-a-Lago imbroglio, and we have in the summertime a subpoena was served and it was returned with an attestation from a unfortunate lawyer on the team, Christina Bobb, saying, "We've done a diligent search, we've looked everywhere." And that turned out to be flagrantly false. They developed evidence that was false, and that was the evidence that they used to justify the search that took place at Mar-a-Lago, because Trump team had not complied with the subpoena, even though they had said they did comply. Okay, how did this happen? The central figure here is a different Trump lawyer, a supervisor of Christina Bobb, who said he told her, hello, Ms. Junior Lawyer, sign this right here. And she actually was prudent enough to just annotate based on things I've been told. So it seems like the course of the conversation was Corcoran saying to her, "We've done a full diligence search." Now, why would Corcoran say that? And we know it was a lie. Could be. He was just, for some reason, acting on his own, taking the lie on himself and completely, falling on his sword for Donald Trump without even telling Donald Trump he was doing it. Could be. Or could be he was in in communication with Trump, and he said, "We've got this subpoena, what do we do?" And Trump said, "Just say we've complied with it." And everything happened from there. Well, that's something that the Department of Justice would like to know. Indeed, if it was something like the latter, another word for it would be very strong evidence of obstruction of justice and knowing non-compliance with a subpoena. We've gotten kind of casual about this as it's come up in the congressional context in the last few years. Subpoena from the DOJ that you you sign under penalty of perjury that you've complied with and you don't, that's serious business. So they had Corcoran. They also had other lawyers in there, including Bob, for interviews with FBI agents. They asked this question, and Corcoran said, "I am citing the attorney-client privilege. I will not answer that question because it concerns confidential communications for the purpose of getting legal advice between me and my client, Donald Trump." So the DOJ said, fine, and went on, and then filed the motion that was reported in a big article from the New York Times yesterday. They go to the chief judge of the D.C. District Court, a woman named Beryl Howell, who's been very strong, by the way, in these things by and large. And it's a side story to note that her term is ending soon, although her putative replacement, a guy named Jed Boasberg, is also really excellent. Anyway, and they said, we want to hear it, force Corcoran to not rely on the attorney-client privilege. And there's a way to do that, and that's called the crime fraud exception. And what you do is you come forward with evidence, a prima facie case, say the lawyers, some reasonable cause to think that the communication in question that the guy will not give you was done in furtherance of a crime. So there's some reason to think that what Trump told Corcoran was in fact part of a crime. This happened before, you may remember, in front of Judge Carter and John Eastman's communications, where the department argued successfully. Carter found it's evidence of a crime, so attorney-client privilege goes away. You can't use the shield of attorney-client communications to commit a crime. either by, with a lawyer, or the lawyers are in it together, or not. Just the client is doing it, but at a minimum, it involves the client communications, because that's what's covered by attorney-client privilege. So Smith's team has filed a motion in front of Judge Howell saying, we want this information, and here's our reasonable cause to think that we deserve it, because the crime fraud exception applies, because Trump's communications were in furtherance of a crime. All this, by the way, is under seal. We learn about it as we normally do, which is leaks, not even leaks. It's from the defense side. Once they're informed of these things, usually they're the ones who leak to the press. And in order to invoke the crime fraud exception, the DOJ had to file a motion, and that motion was copied to the defense, of course. So that's what Beryl Howell is going to hear. All right. It's not completely heart-stopping for the DOJ to seek to pierce the attorney-client privilege. It happens. Not very frequently, but it happens, and you have to have approval to do it. But two things. First, they're saying that what Trump said, we have reason to believe what Trump said is evidence of a crime. So that's a crime, whatever it is, that they would charge against Trump, and it shows Trump is in their crosshairs. And then second, it's just one more instance of Jack Smith treating Donald Trump like any other putative defendant. Maybe at the end of the day, Merrick Garland will make judgments, but Smith is obviously taking his job as pedal to the metal, an aggressive prosecution. One of them happens to be the former president of the United States. That is not cowing him at all. Same as the other day when he slapped a subpoena on Vice President Mike Pence. He's just going for it in a pretty aggressive way, and this is the latest indication. It means more is to come, that we haven't seen that motion, but we'll know what happens when the judge rules on it. The judge might even, as Judge Carter did in California last year, write up an opinion explaining why the government's position that the crime fraud exception applies is well taken or is not. Basically, whether the department has given evidence, not evidence beyond a reasonable doubt as they would need in a criminal trial, evidence by, a sort of certain loosey-goosey and, enough to go forward and pierce the exception evidence. But that these communications by Trump were in furtherance of crime. So that's a pretty big deal, just that they're asserting it, and it's a very strong indication that they think a crime was committed, and that they're looking seriously at charging it under the, of course, criminal standard of beyond a reasonable doubt. So there you have it. A lot more to come on this, including possible leaks about what the defense says in response. But the big point will be when Beryl Howell decides it, and if, like Carter, she pierced the attorney-client exception. That matters in and of itself. It also matters for what it shows or augurs about Donald Trump and a potential obstruction charge. All right, there you have it. Lots more to come, and when it does, I'll be there to explain it. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.